Tonight on the Tread and Truth podcast, I hired a lawyer to help me navigate Arizona court procedure. What I got instead was months of billing on a default track strategy the court later treated as procedurally non-operative, because Rule 15 and the operative pleading issue were never handled cleanly. Then came the retainer confusion, a $2,500 deposit that stayed untouched, demands for more money, and a breakdown later framed as a failure to meet financial obligations, even though the dispute was really over fees, credits, and whether I was being billed for a dead-end track. When I pushed for answers, the response wasn't a fair review, it was a motion to withdraw, and I ended up filing emergency papers to protect my position. This is the story of Gina Carrillo, Gammage and Burnham, the fog bank of Arizona procedure, and what happens when the person you hired to steer the ship leaves you at the wheel in the middle of the storm. This is the Tread and Truth podcast.
Imagine hiring an expert ship captain to navigate a really treacherous, storm-battered coastline.
Right. You're out in the open water.
Exactly. You bring them on board, you hand over the wheel, and you just step back. You let out this massive sigh of relief because finally, a professional is in charge.
And you probably don't know how to read the nautical charts yourself.
I certainly don't.
Yeah.
But you don't need to, right? Because that is exactly what you're paying them for.
Right. They have the expertise.
But then as the journey progresses, you look out the window and you slowly start to realize, wait a minute, they haven't sailed you to safety at all.
Oh, no.
Yeah, they've actually sailed you directly into this dense, completely disorienting fog bank. You start hearing the ship scraping against the rocks. The water's getting really rough.
That is a terrifying situation to be in.
It is. And to make matters worse, as you're sitting there completely lost, panicking, unable to even see the shoreline, the captain just slides an invoice across the table.
Wow.
And they are charging you by the hour for the fog.
That is, it's a profoundly terrifying position, like you said. You are paying for a map and a compass, but what you are actually receiving is, a masterclass in disorientation.
Masterclass in disorientation. I like that.
And the true horror of that situation, I think, is the knowledge gap. Because you are not a ship captain yourself, you just don't possess the vocabulary to argue that the ship is going in the wrong direction.
You just have to trust them.
Exactly. When the expert tells you that, scraping against the rocks is just part of the journey, you are conditioned to believe them, right up until the very moment the ship sinks.
Well, okay, let's unpack this.
Yeah.
Because we have a set of source documents today for this deep dive that detail exactly that kind of sinking ship.
We do, and it's a heavy one.
It really is. We are looking at an official State Bar of Arizona complaint, and it's alongside this highly detailed online narrative published over at unite.org.
Right.
These documents, they outline a Maricopa County Superior Court dispute. So today, we are doing a deep dive into this jaw-dropping paper trail out of Arizona. It basically reveals exactly how the guardrails of the legal profession can just totally collapse.
And what happens to the actual person who gets caught in the wreckage, right?
Yeah, because you usually hear about these David versus Goliath contract disputes. The plucky underdog takes on the massive corporate machine.
The classic setup.
But what if, halfway through the fight, David realizes his own corner team, the people he paid, are actively tying his shoelaces together?
It is a terrifying scenario for any client, really. And it strikes at the very heart of why the legal profession is so heavily regulated in the first place.
Right, because the stakes are just so high.
Exactly. When you hire an attorney, you aren't just buying their time. You are buying their fiduciary duty.
Okay, their fiduciary duty.
Yeah, meaning you are placing your complete trust in their competence to navigate a system that is hostile, complex, and frankly, unforgiving.
And today, we're diving into a deeply documented timeline. This covers early 2025 all the way to March 2026. And it shows what happens when that competence just, isn't there.
We're going to look at a working-class guy, a truck driver, who got into a contract dispute with a corporate giant, Knight Refrigerated LLC.
And he does what you're supposed to do, right?
Yeah.
He goes out and hires a prestigious law firm, Gammage Burnham.
Right. But the journey from signing that engagement letter to eventually finding himself abandoned on the side of the road, legally speaking, is just wild.
So wild.
The documents we are looking at, they tell this chronological story of escalating financial demands, procedural blunders, and a fundamental breakdown in the attorney-client relationship.
So you're going to walk us through the timeline of events involving his attorney, right? Gina E. Carrillo.
Yes. But more importantly, we need to examine this whole thing through the lens of the Arizona rules of professional conduct.
Because this isn't just a bad-yup review situation.
No, not at all. It's a detailed case study in how the ethical duties of competence, communication, and fee transparency are supposed to function, and, what the fallout looks like when they completely fail.
Okay, so take us back to the very beginning, January 2025. This truck driver needs help. He's got a looming deadline to respond to Knight Refrigerated, and he reaches out to Gammage Burnham.
Right.
How does this relationship actually start?
Well, it starts with a tremendous sense of urgency, which is, pretty common in litigation. But it also starts with an immediate red flag regarding the finances.
Uh-oh, like what?
So the client is facing a hard deadline to secure counsel and get a response filed. He has a phone consultation with attorney Gina E. Carrillo. They discuss the scope of the work, and crucially, they discuss her hourly rate.
Okay, standard stuff so far.
Right. And the client decides to move forward based on that conversation. But on January 13th, literally as the formal engagement letter is being prepared and sent over for his signature, the client receives an email from Carrillo.
Okay, what does the email say?
She states that she, quote, might have misquoted her rate during their phone call.
Oh, wow.
Yeah. And in that same breath, she bumps her hourly fee up to $425 an hour.
Wait, right as he's about to sign?
Yes, exactly at that moment.
I mean, he's got a deadline breathing down his neck. He thinks he has his legal team locked in. And at the 11th hour, the price suddenly jumps.
Exactly. You have to look at the psychological leverage at play here. The client is vulnerable. They need counsel immediately to protect their rights against a major corporation.
Yeah, he can't exactly afford to just hit pause.
Right. Dropping a significant rate increase at that precise moment creates a highly coercive sort of take-it-or-leave-it environment. The client is forced to calculate, do I swallow this unexpectedly higher rate, or do I walk away, start my attorney search entirely over from scratch, and risk blowing my legal deadline?
That feels incredibly predatory. I mean, does pulling a bait and switch on your rate right at the finish line violate ethical rules?
It's a complex area, but it definitely strains the boundaries of ethical fee transparency. Under the Arizona Rules of Professional Conduct, specifically Ethical Rule 1.5, an attorney's fee must be reasonable.
Right, reasonable. Which feels a bit subjective, but yeah.
And furthermore, the scope of the representation and the basis or rate of the fee must be communicated to the client, ideally in writing, before or within a reasonable time after commencing the representation.
Okay, so she did communicate it, but the timing is the issue.
Exactly. While attorneys are allowed to change their rates, and, a misquote can genuinely happen.
Sure, people make mistakes.
Doing it at the moment of maximum vulnerability heavily compromises the client's ability to make a free, informed, and unpressured choice about their financial commitment.
Right, because consent isn't really consent if your back is against a wall with a ticking clock.
Precisely.
And it seems like this murky financial foundation immediately bleeds into how they handle his retainer, too, like right from the start.
It absolutely does. Let's talk about the mechanics of the $2,500 retainer the client pays to initiate the case.
Yeah, please break that down, because I think most people assume a retainer is just like a down payment.
Right.
Like I give you $3,000, you work until the $3,000 is gone, and then I give you more.
That is exactly how most clients, and frankly, many law firms operate. It's called an evergreen retainer or a drawdown deposit.
Okay.
The money goes into a specialized bank account called a trust account, specifically an IOLTA, which stands for Interest on Lawyers' Trust Accounts.
Gotcha. So it's legally separated.
Yes. This money does not belong to the law firm yet. It legally belongs to the client until the lawyer actually performs the work, bills for it, and the client has a chance to review the invoice. Only then can the firm transfer the earned money from the trust account to their own operating account.
Okay, so the $2,500 goes into the trust account. The firm starts working. They generate a bill. What happened here that was different?
Gammage and Burnham operated under a completely different structure for this specific engagement. They treated that $2,500 as an untouched security deposit.
Meaning what exactly?
Meaning it was supposed to sit in the trust account, completely unused, and would only be applied to the absolute final bill at the very end of the entire litigation process.
Wow. Okay, so how is he paying for the ongoing work?
The client was expected to pay his monthly invoices out of pocket, completely separate from that initial $2,500.
I could see how that would be super confusing. Did the client even understand that arrangement?
The documents indicate the client believed it was a standard drawdown retainer, based on their initial discussions. And this confusion comes to a head early in the year.
What happened?
So the client is paying his monthly bills, but at one point he experiences a slight administrative delay in getting funds transferred to pay a current invoice via Zelle.
Okay, pretty common issue. Just a bank delay.
Right. So he asks the firm to simply apply a portion of that $2,500 sitting in his trust account to cover the current bill.
Makes sense.
Yeah, assuming he could just replenish the trust account next month when the transfer clears.
That seems like a totally reasonable request to just, keep the gears turning so the work doesn't stop.
Well, the firm pushed back aggressively. They insisted that if he used even a single penny of that trust money to pay the current invoice, the trust must be immediately replenished back to the full minimum balance for them to continue any work whatsoever.
Wait, it's like renting an apartment. You pay a $2,000 security deposit when you move in.
Right.
And then 6 months later, the water heater breaks.
Okay.
You ask the landlord, hey, can you use a little bit of my security deposit to fix the heater right now so I can take a shower? And I'll add that money back to the deposit on the first of the month.
Good analogy.
And the landlord says, no, you can't touch the deposit for maintenance. And if you even ask me to do that, I'm going to evict you.
I see where you're going with that, though. Legally, it's actually a bit more restrictive than a landlord-tenant relationship. A landlord holds the deposit against damages you cause.
Oh, true.
A law firm holds the deposit as a guarantee of future payment for their own services. But your point about the inflexibility is spot on. The firm effectively weaponized the trust account.
Weaponized to how?
They had $2,500 of the client's money safely in their possession. The administrative delay with the Zelle transfer was just that, a logistical hurdle, not a refusal to pay.
Right, he had the money, it was just stuck in transit.
Yet the firm characterized the entire case as being, quote, on hold until the transfer cleared. They halted legal progress over a cash flow technicality despite being fully secured by the trust funds.
That is so frustrating. And while the firm is being incredibly rigid and demanding about the finances, how are they actually performing on the legal side?
Yeah, that's the real issue.
Are they at least delivering flawless work for this premium price?
Not exactly. We see communication and diligence issues surfacing very early on. For example, in June 2025, the firm drafts a filing to submit to the court.
Okay.
The client reviews it and notices a glaring error right at the top. The caption on the court document, the header that identifies the port, the parties, and the case number.
Yeah, the most basic part of the form.
Exactly. It reads Maricopa of Maricopa instead of the correct County of Maricopa.
Okay, Maricopa of Maricopa. On its face, that's just a sloppy copy-paste error, like a typo.
It is a typo, yes.
Yeah.
But Ethical Rule 1.3 requires a lawyer to act with reasonable diligence, and ER 1.4 requires a lawyer to keep the client reasonably informed about the status of the matter.
Right.
When the client spotted this Maricopa of Maricopa error, he asked Carrillo about it. He wanted to know if it was going to be fixed, or worse, if the document had already been filed with the court looking like that.
And what did she say? She must have just said, oops, fix it.
No. According to the client's records, he received no clear, confident answer. The communication just broke down.
That is maddening. If I hire an expensive firm, I'm doing it so I don't have to worry about the headers on court documents.
Exactly. You're paying for peace of mind.
Right. I'm relying on them to police the paperwork. If my lawyer is making weird copy-paste errors on page 1 and then gets evasive when I ask about it, I'm immediately going to start wondering, well, what else are they missing on page 10?
It's a totally valid fear.
Are the actual legal arguments structurally sound?
It erodes the foundational trust of the relationship right away. And it perfectly sets the stage for the escalating tension we see as we move into the summer and fall of 2025.
Because the clock is ticking.
Yes. Because the financial strain we just discussed, this weaponization of the retainer and billing demands, starts colliding directly with the procedural clock of the court system.
Let's get into that. Because the court system waits for no one.
It certainly doesn't.
We are in July 2025 now. What's happening with the case against Knight Refrigerated?
On July 9th, Carrillo emails the client stating the case is, quote, kind of in a hold.
Because of the Zelle thing.
Partially. She reiterates that the client must be completely up to date on his bills for them to proceed with the next steps. Again, keeping in mind that the $2,500 is still sitting untouched in the trust account.
So they are actively stalling his case over a billing dispute, even though they hold a security deposit.
Yes. And a month later, on August 19th, She emails again, noting that opposing counsel hasn't responded to anything and suggests that Knight Refrigerated is simply waiting for Gammage and Burnham to file an application for default against them.
Okay.
But the very next day, August 20th, a bombshell drops. Carrillo notifies the client that the court has placed their case on the dismissal calendar.
The dismissal calendar. That sounds ominous. What does that actually mean mechanically? Does a judge just wake up one day and decide to throw cases out?
Mechanically, courts have an administrative duty to clear their dockets of stagnant cases.
Makes sense. Keep the line moving.
Right. If a certain amount of time passes with no meaningful action or filings by either party, the court clerk's automated system flags the case.
Okay, so it's automated.
Yes. The court then issues a notice saying, in effect, we see no forward momentum here. If you do not take a specific, substantial legal action by a strict deadline, we are going to dismiss this entire lawsuit without prejudice.
So it's the court's way of saying use it or lose it.
Precisely. And in this instance, the court gave them a hard, inflexible deadline of October 20, 2025.
Wow, October 20th.
If they didn't act by October 20th, the truck driver's claims against Knight Refrigerated would be thrown out entirely.
So what's the game plan?
Carrillo advises the client they essentially have two options to beat this clock. They can try to desperately reach out to opposing counsel for a settlement, or they can aggressively pursue that default application against Knight.
And given that Knight hasn't been responding anyway, they choose to go for the default application.
Correct. The client authorizes Carrillo to draft the application for default to save the case from being dismissed. But this is where the timeline gets incredibly tense.
Okay, how tense are we talking?
We know the drop-dead date is October 20th. On September 29th, Carrillo finally sends the drafted default application to the client for his review.
Okay, cutting it a bit close, but September 29th to October 20th. They still have 3 weeks.
They do. But the draft isn't the only thing attached to that communication. In the exact same breath, Carrillo drops a massive, unprecedented financial demand. She informs the client that she wants the required retainer amount increased from the original $2,500 up to $10,000.
Wait, quadrupled?
Yes.
Was a potential $10,000 retainer increase agreed upon in that initial engagement letter we talked about?
Not at all. There was no prior formal invoice or structured agreement for a $10,000 trust minimum. It was an impromptu demand.
That is insane.
And remember, the rules of this specific firm, this $10,000, wasn't to be used to pay ongoing bills. It was a demand for $10,000 of the client's liquidity to be locked away in the firm's trust account, completely untouchable until the final resolution of the case.
That is a staggering amount of cash to demand from a working-class guy on 3 weeks' notice.
It really is. And the pressure cooker is just getting started. The client, despite this shocking new demand, stays focused on the procedural emergency.
Right, he has to keep his eye on the ball, the deadline.
He reviews the drafted legal document and formally approves it on October 10th. He is doing his part to make sure they hit that October 20th deadline.
Good for him.
But the very next day, October 11th, Carrillo delivers an ultimatum.
What kind of ultimatum?
She tells the client she needs an additional $7,500, which is the difference between his current $2,500 deposit and her new $10,000 demand, and she needs it immediately. Furthermore, she states that if she does not receive those funds immediately, she will absolutely not file the time-sensitive, already drafted application for default.
Okay, let's pause here because I really want to understand the gravity of this. The legal document is completely written.
Yes.
The client has approved it. The hard court deadline, the literal life or death date for this lawsuit, is just 9 days away. Can a lawyer actually hold a finished document hostage and play a game of chicken with a court's dismissal calendar just to force a client to hand over a massive new deposit?
You are hitting on one of the most severe ethical tension points in this entire timeline. Let's look at this through the rules.
Okay, lay them out.
We have ER 1.3, diligence, which demands a lawyer act with reasonable promptness in representing a client. We have ER 1.5 regarding the reasonableness of fees.
Right.
And we also have to look at ER 1.16, which governs declining or terminating representation. A lawyer can withdraw if a client refuses to pay their bills, but they cannot prejudice the client's case in doing so.
But he wasn't refusing to pay his bills. He was questioning an uninvoiced sudden demand to lock up 10 grand in a vault.
Exactly. What Carrillo did here created a severe, immediate conflict of interest. She prioritized a sudden, uninvoiced financial demand over the procedural survival of her client's case.
By holding the document back.
Right, by threatening to withhold a fully drafted critical filing with only days left on the clock, she was weaponizing the court's own dismissal calendar against her client.
It's extortionate. I mean, you hire a legal expert specifically because you don't know how to navigate a dismissal calendar. You rely on them to absorb that procedural stress and shield you from it.
Yes, that's their job.
But instead of shielding him from the danger, she's holding him out the window and saying, pay up or I drop you.
It is a profound inversion of the fiduciary duty. The client correctly and vigorously pushed back against this.
He didn't just cave.
No, he argued, quite rationally, that withholding an approved, time-sensitive filing to force a sudden retainer increase would severely prejudice his case. He refused to be bullied by the calendar.
Did she eventually file it? Or did they miss the deadline?
She did. The application for default was ultimately filed on October 16th, just 4 days before the deadline.
Oh, wow. Talk about down to the wire.
But the damage to the relationship was done. The client had been subjected to immense, entirely unnecessary psychological and financial stress generated entirely by his own legal counsel.
So they narrowly escaped the dismissal calendar, the motion is filed, but this just launches them into a completely bizarre new phase of the litigation, doesn't it?
It really does.
Let's look at what happens between October 2025 and February 2026. The case is now on this default track. What does Carrillo tell the client they need to prepare for?
Once the application is filed, Carrillo begins framing the upcoming default hearing to the client. She paints a picture of a massive, highly complex legal undertaking.
How so?
She describes the upcoming hearing as a, quote, mini trial focused on proving damages.
A mini trial? That sounds expensive.
Highly expensive. She estimates it will require upwards of 20 hours of intense preparation.
20 hours.
She talks about the need for extensive live testimony, rigorous coordination of exhibits, and deep strategic planning.
20 hours just to prepare for a default hearing. I mean,
Right.
a default usually implies the other side didn't show up. Why does it require a mini trial?
Well, depending on the jurisdiction and the specific claims, sometimes a judge does require a plaintiff to prove up their damages, even if the defendant defaults.
Okay, so it's not totally out of left field.
No, but Carrillo's framing of the scope was massive. She even went so far as to propose adding another attorney to the billing ledger to handle the workload.
Like an associate attorney to do the grunt work at a lower rate.
She actually suggested that initially, but then she quickly pivoted.
Pivoted to what?
She proposed bringing in an entirely separate outside attorney at a substantially higher hourly rate, pitching this person to the client as a quote-unquote default expert.
A default expert.
Yeah.
Okay, if I'm the client, my head is spinning right now.
Yeah.
I've got this lawyer who just tried to hold my filing hostage. Now she's telling me I need a mini trial, 20 hours of prep, and a high-priced guest star attorney.
Yeah, it's a lot to take in.
How does the truck driver react to this? I mean, does he just go along with it?
This is where we see an incredible moment of role reversal. The client is a working driver, not a legal scholar. But instead of just blindly accepting this massive expansion of the scope and budget, he does something highly unusual for a client.
Does he do?
He sits down, accesses the public docket, and reads the court's actual scheduling documents for himself.
Good for him. Honestly, more people should do that. And what does he find when he reads the actual court orders?
He realizes that Carrillo's apocalyptic framing of a mini trial is completely disconnected from reality.
Really?
Yes. He reads the minute entry and the scheduling orders, and he determines that the court has not requested, nor does it expect, a mini trial.
Are you kidding me?
There is absolutely no mandate in the court documents for a massive, multi-lawyer, 20-hour production.
It's like hiring an architect to design a simple wooden tool shed for your backyard.
Okay, yeah.
And suddenly the architect starts billing you for wind tunnel testing, seismic stress analysis,
Yeah.
and consulting with aerospace engineers.
Right.
And as the homeowner, you literally have to go down to City Hall, read the zoning code yourself, and tell the architect, hey, the city doesn't even require a permit for this. Stop testing my shed in a wind tunnel.
That is a very apt comparison. The client realizes the preparation is wildly disproportionate to the actual procedural reality. He is forced to become the voice of procedural reason in his own case.
That is so backward.
He pushes back hard against Carrillo's plan. He explicitly declines her request to bring in the extra default expert, and he strictly limits the amount of preparation time she is authorized to bill for.
It is wild that a guy driving an 18-wheeler cross-country had a more accurate read on the court's scheduling intent than the high-priced law firm he hired.
It's embarrassing for the firm, honestly.
But does Carrillo listen to him? Does she scale back?
Only marginally. Despite the client's clear mandate limitation, Carrillo still proceeds to bill for substantial preparation.
Unbelievable.
She even runs the client through simulated cross-examinations, treating it as if they are prepping for a grueling adversarial trial on the merits.
Which they weren't.
All of this culminates on the day of the hearing itself, February 11th, 2026.
I really want you to picture this scene, because the contrast between the client's reality and the law firm's reality is just staggering.
It's quite a visual.
It's a virtual court hearing. The client is literally on the clock hauling freight. He has to pull his massive truck over, find a spot at a truck stop, and attend his own default hearing via video chat on a smart device from the cab of his truck, sitting on the side of the highway.
It is a profound image of a client doing everything in his power to participate in the justice system while managing his livelihood.
Right.
So the virtual hearing begins. Commissioner Addison Owen is presiding.
Okay, the big moment.
And after months of buildup, the threats of the dismissal calendar, the $10,000 hostage situation, the estimated 20 hours of prep, the simulated cross-examinations in the truck cab, what actually happens in front of the commissioner.
Let me guess. Nothing.
Absolutely nothing. The client logs in, and his case is just a tiny blip on the court's radar.
Just another file on the stack.
Exactly. There are multiple other cases being heard on the exact same video call. When the commissioner finally gets to his docket number, the entire thing is disposed of in minutes.
Minutes.
There is no mini-trial, there is no grueling cross-examination, there is no need for a default expert. The hearing is just over.
Wow. And the reason it was over so quickly is the most devastating part of this entire story, isn't it?
It really is. The hearing wasn't brief because they won a swift victory. It was brief because, as the client was about to learn, the entire legal foundation that Gammage and Burnham had spent months and thousands of dollars in billable hours building, it did not actually exist in the eyes of the court.
Which brings us to the absolute breaking point. Late February 2026. The procedural wall.
Yes.
Why did they lose so fast?
On February 19th, 2026, the court issues its formal ruling via a minute entry.
Okay, really quickly, because I think people hear minute entry and they imagine someone sitting in the courtroom with a stopwatch.
Yeah, that's a common misconception.
What actually is a minute entry, mechanically speaking?
That's a great question. A minute entry has nothing to do with the stopwatch. In court administration, a minute is a historical term for the official, abbreviated record of what transpires during a court proceeding or a directive issued by a judge.
Oh, like taking meeting minutes.
Exactly. Historically, the court clerk would furiously write down the minutes of the meeting, the official summary. Today, a minute entry is simply the formal, written document distributed by the court clerk's office that records a judge's orders, rulings, or the summary of a hearing.
Got it. It is the official communication from the court to the parties.
Precise.
So the official communication comes down on February 19th. What does Commissioner Addison Owen's minute entry actually say?
The minute entry formally denies the defendant's motion for entry of default judgment.
Denied.
It denies it without prejudice, and it refers the entire matter back to the main judge assigned to the case, Judge Moskowitz. But the critical, explosive part of this document is why the commissioner denied the default.
Right. What was the fatal flaw? Why did it get kicked back?
The court ruled that there was, quote, no operative pleading upon which the court could possibly enter a default judgment.
No operative pleading.
Yes.
Break that down for us in plain English. What makes a pleading inoperative?
It means the foundational document that Carrillo was basing this entire month-long strategy on was legally invisible.
Invisible.
The court essentially looked at the docket and said, we cannot grant a default judgment based on this document because as far as the rules of civil procedure are concerned, this document does not exist.
How does a document filed by a law firm just not exist? I mean, they filed it.
Yeah. We have to trace the timeline back to the summer to understand why. 8 months prior, on June 11, 2025, Carrillo had filed a document that was effectively an amended counterclaim against Knight Refrigerated.
Okay, so she updated the paperwork.
She changed the substance of the lawsuit. However, under Arizona's Rule 15 of civil procedure, you cannot simply file an amended pleading whenever the mood strikes you.
Why not? Why can't you just update your lawsuit if you find new info?
Because if parties could unilaterally change their claims at any moment, the legal system would be pure chaos.
Oh, I guess that's true.
A defendant could never adequately prepare a defense if the plaintiff kept secretly swapping out the allegations. So Rule 15 acts as a gatekeeper.
Okay.
It mandates that after a certain early window passes, if you want to amend your claims, you must formally seek the court's permission.
So you have to ask.
In legal terms, you must file a motion seeking leave to amend. You ask the judge, may I please change my filing? And the judge grants or denies it.
And Carrillo didn't ask permission.
Precisely.
Right.
The commissioner explicitly noted in the minute entry that the defendant filed its amended counterclaim, quote, without seeking leave to amend.
Oh my God.
Because Carrillo failed to comply with that basic fundamental procedural requirement of Rule 15, the court considered the amended document defective.
So it was just void.
It was a non-entity, and you cannot grant a default judgment on a ghost document.
This is a huge distinction we need to highlight, because later on, Carrillo tries to brush this whole thing off to the client as just normal, like, litigation risk.
Which is incredibly misleading.
Like, hey, sometimes you go to court and the judge just disagrees with your brilliant argument. You win some, you lose some.
That is a massive mischaracterization. We must clearly define the difference between losing on the merits and losing due to a procedural defect.
Yeah, please do.
Losing on the merits means you followed all the rules of civil procedure. You filed everything correctly. You got into the courtroom, you presented your evidence, you made your legal arguments, and the judge or the jury simply found the other side's case more persuasive.
Like losing a fair fight.
That is true litigation risk. You
Yeah.
can execute flawlessly and still lose on the merits.
But that is absolutely not what happened here.
No, a procedural defect means you never even made it to the argument because you failed the basic entry requirements of the court. It is an administrative, technical failure to follow the instruction manual.
It's like, okay, earlier I said it was like a pilot crashing a plane on the runway and calling it aviation risk.
Yeah.
But it's not even that, is it?
It's worse. It's like a pilot forgetting to file a flight plan with the FAA.
Wow. Yeah.
The control tower grounds the plane before the engines even start, and the pilot turns around to the passengers sitting at the gate and says, well, folks, we hit some unexpected turbulence. That's just the risk of flying.
They never even got off the ground.
Exactly.
And this brings us to a devastating evaluation of Ethical Rule 1.1, right?
Competence.
Yes, ER 1.1. The bar rules state that competence requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation.
And missing Rule 15. Understanding something as foundational as Rule 15, knowing that you must ask permission to amend a pleading, is first your law school stuff. It is the absolute floor of competence.
And the human cost of that incompetence is just immense. I mean, think about it. The client endured months of billing for this default strategy.
The financial drain alone is staggering.
He endured the massive stress of the looming dismissal calendar. He endured the highly coercive $10,000 retainer ultimatums. He prepped for a non-existent mini-trial from the cab of his truck.
All for nothing.
And every single second of that stress and every single dollar billed was based on a legal track that was dead on arrival 8 months earlier due to a rudimentary procedural error by his own lawyer.
That's the tragic reality of it.
So the truth is finally out. The minute entry was in the client's hands. He knows the firm made a massive procedural blunder.
He sees it in black and white.
In a normal business relationship, if a vendor makes a catastrophic error that costs you time and money, you expect a profound apology. You expect them to make it right. You certainly expect a massive adjustment to your bill.
That would be the ethical professional response, yes?
So what happens next? Does Gammage and Burnham fall on their sword?
Not even close. Instead of an apology, the client is hit with another massive financial demand, which leads us to the ultimate breaking point between late February and March 2026.
The ultimatum and the silence of the partners.
Exactly.
Walk us through the emails after the minute entry drops.
On February 27th, just 8 days after the disastrous minute entry, Carrillo emails the client to outline her proposed path forward.
How is she spinning this?
She says they now need to narrow their claims, and they have to contact Knight's counsel to essentially beg for their retroactive permission to amend the counterclaims properly this time.
Okay, so hat in hand to the opposing side.
But then she drops the hammer again. To continue handling this matter, to fix the very mess she created, she demands, once more, that the client increase his untouchable trust retainer to $10,000.
The audacity is just breathtaking. I forgot to ask the court for permission. Our case blew up. Now give me $10,000 to clean it up.
It really is hard to believe.
How does the client respond? Because at this point, he has to know he's being taken for a ride.
The client's response on March 3rd is remarkably composed, rational, and logical. He essentially says, a fee review and a credit must come first.
Smart.
He points out to Carrillo that the massive procedural detour they just spent 8 months on was entirely the firm's error regarding Rule 15.
Because it was.
Right. And he asks to resolve the financial credits for the non-operative wasted track before he will even consider approving a massive new retainer increase.
That is the most reasonable business response imaginable. Audit the bill for the defective work before we talk about new money.
Any standard business would agree to that.
What is Carrillo's reaction?
She flatly refuses. She emails him back, stating, quote, an adverse ruling does not make the work performed improper or that the associated fees are refundable.
Oh, come on. She is still gaslighting him.
She is.
She's still clinging to the narrative that failing to follow basic civil procedure is just a normal adverse ruling from a grumpy judge, rather than a fundamental defect in her own legal work.
Precisely. So the client realizes he has hit a brick wall with Carrillo. She refuses to acknowledge the procedural reality, and she refuses to audit the bill.
So what's his next move?
So on March 9th, the client does exactly what you're supposed to do in a corporate structure. He escalates, he goes over her head.
Who does he go to?
He drafts a detailed, comprehensive email, and he sends it directly to the senior partners of the firm, the names on the door.
Oh, wow.
He emails Grady Gammage Jr. and Richard B. Burnham directly.
What does he say to the named partners? Like, how does he lay this out?
He lays the entire saga bare. He requests a formal, firm-level review of the billing. He demands a trust ledger to see exactly where his $2,500 security deposit has been sitting this entire time.
Which he has a right to see.
Absolutely. He clearly outlines the procedural failure regarding Rule 15, citing the judge's minute entry. He details the highly coercive, deadline-driven financial pressure he was subjected to in October.
The hostage situation.
Right. And he even asks if it might be possible to have his case reassigned to a different, more competent counsel within the firm.
He is laying out a massive liability issue for the firm. I mean, he is documenting potential ethical violations occurring right under their roof.
It's a very serious email.
As named partners, their personal reputations and the firm's liability are on the line. How do Grady Gammage Jr. and Richard B. Burnham respond to this detailed plea?
They respond with total, absolute silence.
Wait, silence.
Neither partner replies to the client. They do not acknowledge the email. They do not initiate a fee review. They do not intervene to correct the procedural or ethical flaws occurring under their supervision.
This absolutely blows my mind. The culture of the legal profession often projects this image of noble, self-regulating prestige.
Yes, that's the ideal.
But let's look at it like a retail transaction. If you buy an expensive television from a big box store, take it home, and it doesn't turn on, you take it back.
Right.
You don't keep arguing with the cashier who sold it to you. You ask for the store manager. And if you show the manager that the TV is completely hollow inside, and the manager just stares at you in silence and refuses to refund your money, what does that tell you about the company?
It tells you that the institutional culture is designed to protect the revenue, not the consumer. The silence of the partners speaks volumes. When a firm's senior leadership ignores a documented, rational plea regarding basic competence and coercive billing tactics, it strongly suggests an internal environment where protecting the firm's financial positioning and closing ranks around the attorney's actions supersedes their fiduciary duty to the client.
Just circling the wagons.
Exactly. Their silence was a tacit institutional endorsement of Carrillo's conduct.
And because the partners stayed completely silent and offered no oversight, Carrillo was free to pull the ripcord on the entire relationship.
That's right.
Which brings us to the final, most brutal chapter of this timeline, March 2026. The withdrawal and the smear campaign.
Having ignored the client's request for a firm-level fee review and having failed to secure the uninvoiced $10,000 retainer demand, Gammage and Burnham takes aggressive action to terminate the relationship.
Okay, what do?
On March 12, 2026, Carrillo files a formal motion to withdraw as counsel with the court.
Now, lawyers are allowed to withdraw, right? Sometimes it just doesn't work out.
Yes, ER 1.16 outlines when and how an attorney can withdraw.
But it's the way she does it that is so shocking here. The language she uses in this public court document is a full-on character assassination. What exactly does she claim in the public record?
In the motion to withdraw, Carrillo claims there has been an irreconcilable breakdown in the attorney-client relationship.
Okay, standard boilerplate.
But much more damagingly, she explicitly cites a failure by defendant/counterclaimant to fulfill his financial responsibilities as a client.
She calls him a deadbeat in the public court record.
Basically, yes.
But let's look at the actual facts at that exact moment in time. Was he actually failing his financial responsibilities?
We must evaluate this under Ethical Rule 8.4, which deals with misconduct, specifically engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation.
Okay, so what was his financial status?
At the precise time this withdrawal motion was filed to the court, the client's regular operating invoices were fully current. He had paid his bills for the work performed.
So he was all paid up.
Furthermore, the original $2,500 retainer deposit was still sitting, completely untouched, in the firm's trust account.
Wait. His bills were paid. They had his $2,500 security deposit. So what on earth was the claim of financial failure based on?
It was based entirely on his refusal to blindly wire them an additional $7,500 to meet their new, uninvoiced $10,000 retainer demand until they conducted the fee review he asked for.
You've got to be kidding me.
To reiterate, the firm had never even issued a formal invoice for that $10,000 increase. It was just a demand made via email.
So let me get this straight. Carrillo takes a private dispute over a requested audit of her own defective work
Yes.
and a disagreement over a new unbilled retainer demand. And she twists that private dispute into a public declaration to a judge that the client refuses to pay his bills.
Yes. She utilizes the public court record to smear the client's financial reputation in order to justify abandoning a case that she herself had procedurally derailed.
It feels like the ultimate unforgivable betrayal. You hire a legal expert to navigate you through a treacherous fog. They take the wheel and immediately crash your boat into the rocks because they didn't read the map.
Right.
They demand $10,000 to fix the hole they just blasted in the hull. And when you say, hey, shouldn't you cover the damages from your own crash first before I give you more money? They jump ship.
The very accurate metaphor.
And not only do they jump ship, on the way down they radio the Coast Guard, the judge, and the opposing corporate giant and tell them all that the ship is sinking because you were too cheap to pay for gas.
Yeah.
How does a client ever recover from a smear like that?
The personal and legal impact of that withdrawal motion is devastating, and it operates on multiple levels.
It's like the optical damage, right?
First, consider the optical damage within the lawsuit itself. By permanently branding the client in the public court records as financially irresponsible and uncooperative, the firm paints a massive target on his back.
Because Knight Refrigerated is watching all this.
Exactly. They make the client look incredibly vulnerable, financially depleted, and unstable to opposing counsel. Knight Refrigerated now knows this guy is bleeding out. It is blood in the water for a corporate giant.
And what happens to the truck driver physically? I mean, he's out on the road, he has no lawyer, he's facing a corporate machine.
He is left completely stranded because his lawyers abandoned him right as the procedural mess they created was hitting the fan. He is forced to manage emergency pro se filings.
Pro se.
Pro se means representing oneself without an attorney.
Which is incredibly hard for a non-lawyer.
He has to scramble to draft his own legal documents, figure out how to format them, and file them with the court just to protect his position and formally object to the firm's withdrawal.
While working a full-time, demanding job.
He has to learn the intricate rules of civil procedure on the fly, reading PDFs on a cracked phone screen in the cab of his truck, while simultaneously trying to drive his routes and earn a living. The psychological toll is immense.
And it wasn't just the Arizona case that got damaged, right? Didn't this entire 8-month wild goose chase compromise his other legal options?
It absolutely did, and this is a crucial piece of collateral damage. Prior to getting bogged down in this Arizona lawsuit, the client actually had a backup legal angle.
Oh.
Back in April 2024, he had utilized another attorney to send a formal notice letter under the Texas Deceptive Trade Practices Act, commonly referred to as the DTPA.
What is the Texas DTPA?
The DTPA is a powerful consumer protection statute in Texas designed to protect individuals against false, misleading, and deceptive business practices.
Okay, so a totally different route.
It was a completely different, highly viable avenue for justice against his former employer. And the client had explicitly communicated to Carrillo that he wanted to keep this Texas DTPA path alive and protected as a strategic backup.
But the clock is always ticking. Let me guess, a statute of limitations issue.
Precisely. The Texas DTPA generally carries a strict 2-year statute of limitations. The clock was running.
And they wasted how much time?
The 8 months that Gammage and Burnham wasted aggressively chasing a non-operative, procedurally defective default track in Arizona, followed by their sudden and chaotic abandonment of the case, ate up massive amounts of that timeline.
Wow.
The procedural delay wasn't just a waste of his money in Arizona, it potentially cost him his alternate route to recovery in Texas by pushing him dangerously close to the statute of limitations wall.
It is just a staggering, compounding cascade of failures, a masterclass in how a client can do everything right. Hiring a known firm, paying their bills, trying to read the documents and still get completely chewed up by the machinery.
It is. From the bait-and-switch rate increase on day one, to the weaponization of the trust account, to the failure to grasp Rule 15, to the coercive deadlines, and finally the misrepresentations in the withdrawal. It is a systematic failure of fiduciary duty.
So, as we wrap up this deep dive, what is the core takeaway for you, the listener? Why did we spend all this time unpacking the misery of one truck driver in Arizona?
Because it could happen to anyone.
Right. If you ever find yourself in a position where you need to hire legal counsel, whether it's for a contract dispute, a divorce, or a business deal, you need to remember the stark warning put out by the advocacy group unite.org.
That's the letter U-Knight.org.
A play on the word unite, exactly. Their warning, born from this exact case study, is brutal but necessary. You must police your own attorneys.
It is a harsh reality to accept. We want to believe that the system polices itself.
Yeah, you assume they know what they're doing.
But you cannot blindly trust that the prestige of a law firm or the expensive hourly rate guarantees competence or ethical financial dealings. You must be an active participant in your own defense.
Ask questions.
You must ask for your trust ledgers to see exactly where your deposits are. You must read your own court scheduling orders and minute entries. And you must never, ever let an attorney hold a critical court deadline hostage in exchange for an uninvoiced, impromptu retainer demand.
It completely shatters the illusion of the trusted advisor, doesn't it?
Right.
We spend so much time in our society talking about holding massive corporations like Knight Refrigerated accountable for how they treat their workers, for misclassification, for shady contract disputes.
True.
But this story forces us to look in a different direction. Who is watching the watchmen? Who holds the legal gatekeepers accountable when they are the ones doing the damage?
That is the lingering, uncomfortable question. The systems of accountability within the legal profession, like the state bar disciplinary boards, do exist, but they are almost entirely reactive. They operate years after the fact. The tangible damage to the client's case, to their financial stability, to their alternate legal strategies, and to their psychological well-being has already been permanently done by the time a formal complaint is ever filed or investigated.
Right. When a prestigious law fund can literally bill you thousands of dollars for procedural detours created entirely by their own failure to read the rule book, and then, when you rationally ask for an accounting of those errors, they permanently brand you in the public court records as a financially irresponsible deadbeat just to cover their own exit. You really have to wonder,
Yeah, you do.
is the justice system actually designed to protect the client? Or has it evolved into a structure designed to protect the firm and the revenue at all costs?
Sobering thought.
It is definitely something for you to chew on very carefully the next time someone slides a dense, multi-page engagement letter across a polished conference table for you to sign. This brings us to the end of our deep dive into this phenomenal source material. It has been a really intense journey. What we have looked at today isn't just a grievance about a high bill. It is a masterclass in the severe risks of blind trust in professional services.
It truly is.
It shows exactly how the court system, the pressure of billable hours, and incredibly dense procedural rules can combine into a labyrinth that completely preys on the uninitiated consumer. You hire an expert guide to get you out of the maze, and they end up charging you rent to stay lost in it.
It is a profoundly sobering reality check for anyone interacting with the legal system, and it raises a much larger systemic question that I want to leave our listeners pondering today.
What's up?
We, as a society, rely on lawyers because the legal system is intentionally built to be too complex for the average person to navigate on their own. The rules of evidence, Rule 15, minute entries, it is a foreign language.
It really is.
We grant these professionals a monopoly on access to the courts, trusting that the ethical rules of the state bar will keep them in check and protect the consumer.
That's the social contract.
But if you look at the state law complaint we just spent the last hour analyzing, the level of legal knowledge required to write it is astounding.
It's incredibly detailed.
The meticulous citation of minute entries, the deep understanding of Rule 15 and operative pleadings, the precise mapping of ethical rules to firm behavior. The complainant essentially had to become a legal scholar just to write a coherent complaint about their own attorney's incompetence.
Oh, wow.
So the provocative thought is this. If the regulatory system designed to police lawyers requires the victimized client to possess the expertise of a lawyer just to properly report the abuse, who is the system actually protecting?
Wow. That is, yeah. If you need a law degree to successfully complain about your lawyer, the game is truly rigged from the start.
Yes.
That is a heavy thought to end on.
It is.
Thank you for joining us on this deep dive. Remember the ship captain in the fog bank. Don't just sit there and blindly pay the invoice for the fog. Demand to see the compass. Learn how to check the map yourself, and never ever be afraid to ask why you're sailing in circles. Stay curious, stay vigilant, and always check the receipts.
Mega carrier fuel cards are sold like a benefit. But for a lot of leased owner-operators, the real question is, who is the benefit really helping? A few cents off at the pump may sound good. Until the discount is tied to a network, the rebate comes later. The formula is hard to verify, and the fuel protection scale stops short of real-world diesel prices. That is why United Freight Haulers is putting fuel card information in front of drivers who want to compare the numbers for themselves. Do not just take the carrier's word for it. Look at the math. Look at the structure. Look at your options. Visit u-knight.org today. That is u-knight.org. Knight is spelled with a K. u-knight.org. United Freight Haulers, helping drivers ask better questions before the next fuel stop.